Greetings and welcome everybody. My name is Zach Sarkis and I'll be your host today. This is our part number 11 for the New York Cannabis Legalization Workshop Series hosted here by HempLab. We are diving into part 2 of the general provisions in Article 6 through the MRTA, the Marijuana Regulation Taxation Act. We've been going line by line, or at least section by section, through the entirety of this bill since it's been passed, hopefully providing a clear and conversational based platform for folks to understand the law at hand for New York legalization. I'm joined today by my co-host and HempLab board member, Jason Klimek, and we also have our colleague, Mary Kruger, who is Executive Director of NORML, who should be joining us at any moment in time. Well, Mary, perfect timing. And yeah, we're stoked to be here. We're happy to be putting this together. It's something, you know, some may feel it's a tedious task, but honestly, we find a lot of joy in breaking this down and really our intention is to provide, you know, clear understanding in an accessible way so folks can have a better understanding of the law and how that impacts them moving forward. As for folks who are on this call, please stay lively in the chat. If you have any questions, you can use the Q&A, you can use the chat. We're here. That makes this presentation a little more dynamic. And yeah, I think I will pass the torch off to Jason. Just give us a little introduction about yourself and why we're here today, what we're looking at.
So I'm Jason Klimek, I'm an attorney at Woods Ovie Gilman in the cannabis practice and tax practice. Today we're continuing with the general provisions. So I think we might get into some of the, you know, criminal aspects of what has changed, what is now prohibited under criminal law. Yeah, so, you know, generally applicable provisions. I think we may, you know, skip some of the more dry aspects, you know, more ministerial things, but if we skip anything that you feel might be important, feel free to shoot us that message in the chat or the question. We'll go back and address it. But, you know, to try to just kind of skip over the things that are going to be less important for people involved in the industry and more just kind of how things are going to be governed at the board or something like that. You know, we might just kind of skip over that to get to the more substantive stuff. So as I said, if you want us to dive into it, just let us know.
Love that, appreciate that. Mary Kruger, you want to just say what's up and introduce yourself?
Yes, I'm on a computer with a working camera today. So I am Mary Kruger. I'm the founder and executive director of NORML. We are the Rochester affiliate of the National Organization for the Reform of Marijuana Laws. So we are a nonprofit who is focused on advocating for cannabis consumers and here to offer that perspective.
Great, thank you so much for being here, Mary.
Thanks for having me, Zach.
Before diving too deep into Article 6, just got to give a big shout out to our sponsoring members, Harris Beach Law Firm. They've been with us from the start, helping keep the Zoom call rolling over the past couple of years now, or almost a couple of years. And also big shout out to our 2021 sponsoring members, Mad Hatter's Hideaway Smoke Shop out here in Rochester and the Wagner Firm PLLC. Big shout out to our founding business members, folks who have also been with us from the start, Boylan Code, Attorneys at Law, Canamil, Forefathers Innovation, Singer Farm Naturals, the NYC GPA, that's the New York Cannabis Growers and Processors Association, Dawson Law Firm, Tracy John Law Firm, and Closed Loop Systems. And big thank you to our 2021 business members, No Wave, Beacon Skiff, Plant Science Labs, Hellendale Dermatology, EFPR Group, and CBRE. Super grateful for y'all and all of our individual members out there who've been supporting us, and the folks who paid $10 to be on this or are watching it following up. Super grateful for your support, and you keep us motivated to keep on keeping on. So let's dive into where we picked up. I think we left off on section 133 of the general provisions. And this is beginning to talk about the revocation of registrations or license and permits for cause and the procedure for revocation or cancellation. Jason, do you want to pick up on this and then I'll take the next section?
Sure. So any registration, license, or permit issued pursuant to this chapter may be revoked, canceled, suspended, or subject to the imposition of civil penalty for cause. there shall be a rebuttable presumption of revocation for each of the following. So that means that they basically will revoke for each of the following unless you can prove it's not true. Conviction of the registered organization, licensee, permittee, or his or her agent or employee for selling any illicit cannabis on the premises registered, licensed, or permitted, or the transferring, assigning, or hypothecating, which means putting basically a lien against it, a registration, license, or permit without prior approval of the office. So you do one of those two things, your license is revoked unless you can prove that it didn't happen. Or, I mean, actually, there's not even a knowing element in there. So a conviction of the registered organization, blah, 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 for selling any illicit cannabis on the premises. So it's not knowingly selling. So that one's a big, caution that as written could change in the regulations. But if any illicit cannabis is sold, that's a potential for revocation. So notwithstanding the issuance of a registration, license, or permit by way of renewal, the board may revoke, cancel, or suspend such registration, license, or permit, and or may impose a civil penalty against the holder of such registration, license, or permit as prescribed by the section for causes or violations occurring during the license period immediately preceding the issuance of such registration, license, or permit. So the term for cause, very important. Shall also include the existence of a sustained and continual pattern of misconduct, failure to adequately prevent diversion or disorder on or about the registered, licensed, permitted premises, or an area in front of or adjacent to the licensed or registered premises, or in any parking lot provided by the registered organization or licensee for use of those organizations' patrons, which significantly adversely affects or tends to significantly adversely affect the protection, health, welfare, safety, or repose of the inhabitants of the area in which the registered or licensed premises is located.
So I think that's an interesting thing that, it's like, it's not just, it's like failure to adequately prevent diversion. Diversion is leakage, and that could mean someone on your team is doing a backdoor deal. And like, I think one thing that's been very, very clear on the West Coast has how easy leakage is. We're talking about a plant that could be grown in backyards in New York State at this point in time. So that kind of muddles the environment of availability, let alone, we're looking at a cultivator, we're looking at a processor, or specifically a retailer. The places how illicit cannabis or diversion can happen are pretty damn substantial. So looking at where the accountability lies, it's in the license holder, not in the employee, not in the manager, and all the folks who are tied to that license, so investors, et cetera. It could trickle upstream pretty quickly. So I think that's just important to underline.
Yeah, definitely. I mean, your employees could, if they diverted cannabis, could render your license revoked. So it's very important to, have good people on your team and be monitoring the entire situation. So term for cause also means deliberately misleading the board or Office of Cannabis Management as to the nature and character of the business to be operated by the registered organization, licensee, or permittee, or by substantially altering the nature or character of the business without seeking appropriate approvals from the board. So basically, don't lie to the board. Let's see. Substantially altering the nature or character means any significant material alteration to the scope of the business activities conducted by the registered organization that would require obtaining an alternate form of registration. So pretty much, don't tell them you're a cultivator and then start processing. Things like that.
Yeah.
Let's see, as used in this chapter, the existence of a sustained and continuing pattern of misconduct or disorder on or about the premises may be presumed upon the sixth incident reported by the board by a law enforcement, reported to the board by a law enforcement agency, or discovered by the board during a course of investigation. So apparently you get 5 chances before it's a pattern, which is relatively generous. Usually like they start at 3. So, they'll give you 5 chances, I guess. Let's see, during the course of investigation of misconduct or disorder or on or about the premises. Absent clear and convincing evidence of either fraudulent intent or on the part of the complainant or factual error with respect to the content of any report concerning such complainant relied upon by the board. Any registration license permit issued by the board pursuant to this chapter may be revoked, canceled, or suspended, and or be subjected to the imposition of monetary penalties set forth in the chapter in the manner prescribed by the section. The board can, on its own initiative or on a complaint, institute proceedings to revoke, cancel, or suspend an adult use cannabis retail dispensary license or adult use on-site consumption license, and may impose a civil penalty against the licensee after hearing. So that's interesting that it's solely focused, that provision, on the retail side of things. See, all other registrants, license, or permit issued under this chapter may be revoked, canceled, or suspended, or may be subject to the imposition of a civil penalty by officers after a hearing to be held in such manner and upon such notice as may be prescribed in regulation. So basically, in the first part, if you're selling illegally to your retail licensee, you're selling illegally, they can quickly bring you into a hearing, at which point they will revoke your license or there will be a hearing on that. The other one is only for all other licenses. After a hearing is held, they could revoke your license. So you're afforded a little bit more due process. If you're on the wholesale side, I'm not really sure why the disparity there off the top of my head. I mean, I'm sure if I thought about it a little bit, I could come up with something.
Well, it's interesting. It almost seems counter, again, to like the bill itself, the social equity bill that wants to empower small businesses, wants to empower folks and like decriminalize cannabis, like, you know, on a complete level. And then it's like, but the folks who are working direct to consumer, which, you know, you read the language in the bill, is in many cases seems to want to prioritize social equity applicants, are those who will be exposed to an immediate revocation versus the folks who hold the other license maybe have more of a window, or again, the like,
oh, no,
have
so
a hearing.
the difference is they're both after a hearing, but the difference is the board on its own initiative could look into retail dispensaries. Whereas apparently that is not the case with the second one, or a complaint for the retail dispensaries. It's just interesting, like, but you notice this is a whole thing throughout the entire law where they are treating the two sides of the market very, very differently in a lot of respects. So it's just interesting. That'll be interesting to see how the regulations come out on that, because they're almost the same, but they're still different.
Totally.
All right, let's see. Where a licensee or permittee is convicted of 2 or more qualifying offenses within a 5-year period, the office, upon receipt of notification of the second or subsequent conviction, shall, in addition to other sanctions or civil or criminal penalties imposed pursuant to this chapter, impose a civil penalty not to exceed $10,000. A qualifying offense means the sale of cannabis to a person under the age of 21, not otherwise authorized by this chapter. For the purpose of the subdivision only, a conviction of a licensee or employee or agent of such licensee shall constitute a conviction of such licensee. So again, holding you responsible for your employees, but basically the same as the alcohol law, right? You know, if you sell to a person under 21, that's the issue that they're trying to tackle here. So maybe, you know, a good idea is to take the Wegmans approach and just card everybody.
Yeah.
You know,
True.
take the judgment out of the equation. Don't lose your license.
Yep.
All right. The board may adopt rules and regulations based on federal guidance, provided those rules and regulations are designed to comply with federal guidance and mitigate federal enforcement against the registrations, licenses, or permits issued under this chapter or cannabis industry as a whole. This may include regulations which permit the sharing of licensee, registrant, or permit holder information with designated bank or financial institutions, provided these regulations are designed to aid cannabis industry participants' access to banking and financial services. That would be wonderful if we could get those. Hopefully that will be on the way someday. Lawful actions. So you can contract. Basically, all right, so this will sum up a lot of things in this section. Basically, when you do illegal things, those things aren't enforceable. Like, so if we were to contract for this, if Zach and I were to contract for the sale of heroin, let's say, and we are not licensed pharmacies, and it's heroin, Zach can't take me to court and say, well, he breached the contract, because it's a contract for an illegal thing. So what this is saying is, despite the fact that it's illegal at the federal level, you can still contract or get around all of these things for cannabis, and that's enforceable. So it's important, because we did see in the hemp realm a lot of issues come up where people weren't abiding by their contracts. And if it was not, if this section 134 didn't exist, you could make the argument in court, well, it's an illegal substance and therefore we can't contract on it. So that's kind of what this is getting at. Let's see. So this is all just kind of describing all of the things that aren't illegal, but it's very, normal business things: purchase, cultivation, possession, consumption of cannabis, the actions of the employees. So, if you're doing normal business things that are legal, but they just happen to involve cannabis, they are legal, they are enforceable, and you're not going to get, barred from some court action purely because you're dealing with a federally illegal substance. But it's important to have that.
Yeah, kind of ends saying the purchase, cultivation, possession, or consumption of cannabis and medical cannabis as permitted by law and consistent with the rules and regulations of the board. So it's basically just saying, like, cannabis is hereby recognized as legal. So things that were previously considered illegal now fall under the guise of this particular section. Thus, it can be held up in court.
Yep. Review by the courts. An action by the board shall be subject to the review by the Supreme Court. Just note, Supreme Court is the lowest level court in New York. It goes Supreme, Appellate, Court of Appeals. So basically, you can appeal any ruling of the board to the Supreme Court if you are so inclined. So that's what this is allowing for.
So just real quick, it's refusal to be issued a registration, license, or permit, the revocation or cancellation of a permit, the failure or refusal of the board to render a decision upon any application or hearing submitted within 60 days after the hearing, a transfer by the board of registration, license, or permit to any other entity, or the failure or refusal of the board to approve such transfer, refusal to approve alteration of premises, and refusal to approve corporate change in stockholders' ownership, etc.
So basically, if you disagree with a board's decision, you can take them to court.
Yeah.
Illicit cannabis is going to be
a big one. Yeah.
Let's see. It means and includes any cannabis flower, cannabis concentrate, cannabis product on which any tax required to have been paid under the applicable state law has not been paid.
Yeah.
So, I mean, that's really what it comes down to is if you should have paid tax on it, which means you should have had a license and paid tax on it, then it's illicit cannabis. That's how they got to it through the definition, is really just putting it in kind of almost the tax realm. Illicit cannabis shall not include cannabis lawfully possessed in accordance with this chapter or the penal law. So gifting of cannabis, as I think we see later on, or I can't remember if we already talked about it, is legal. So it's not that part, because you can gift cannabis and it is not illicit cannabis. But if you try to then sell that cannabis, now you have an issue because there should be tax on that. Let's see. Any person holding a license, permit, or registration under this chapter who shall knowingly possess or have under his or her control any cannabis known by a person to be illicit cannabis is guilty of a Class B misdemeanor. So misdemeanors are less than a year in jail. I don't recall what a Class B is, some number of months.
Again, it must be known and just underlined. It's like any person holding a license or permit or registration. So this isn't for the average public. This is if you're doing business in this industry and you have any cannabis known by if you know that you have any, if you get caught and you have cannabis on you that is illicit and you knew it was illicit, that's a Class B misdemeanor.
And that's, very common in criminal law is that's called the mens rea requirement. It's the you had the mental state, you knew. So like that's distinguished from strict liability. An example of strict liability is speeding. You don't have to know that you're speeding. The fact that you are speeding is enough to get, you know, a ticket. This is the prosecution would have to show by beyond a reasonable doubt that you knew it was illicit cannabis. So it is a pretty high burden for them to prove. Like they really would have to have good evidence that you are doing something with illicit cannabis that you're not supposed to be doing. So yeah, again, pretty high burden. Let's see. Next, any person holding a license, permit, or registration pursuant to this chapter who shall knowingly barter, exchange, give, or sell, or offer to barter, give, exchange, give, or sell any cannabis known by the person to be illicit cannabis is guilty of a misdemeanor.
And again, illicit cannabis is cannabis that has not been taxed, that should have been in this case.
Any person holding a license, permit, or registration pursuant to this chapter who shall knowingly possess or have under his or her control or transport any cannabis known by the person to be illicit cannabis with the intent to barter, exchange, give, or sell such cannabis is guilty of a Class B misdemeanor. So that now includes the transportation. So that could include distributors.
Now, back up to paragraph 3, it says guilty of a misdemeanor, but well, paragraph 2 said Class B, and then Class 4 said Class B. Do you think they just forgot to put Class B, or is it just any misdemeanor?
So I cannot remember because literally don't ever rely on me for criminal law stuff other than like the most basic, but I am relatively certain that if it doesn't specify the class, then it's an unclassified misdemeanor, which has its own criminal term attached to it, like, you know, X amount of months or something like that. So my guess is that was intentional, that they wanted to fall within that bracket as opposed to whatever Class B is. But that's just a guess in my recollection back to, I don't know, over a decade ago in my criminal law class.
Okay.
So take that for what it's worth. Any person who, being the owner, lessee, or occupant of any room, shed, tenement, booth, building, float, vessel, or part thereof, who knowingly permits the same to be used for the cultivation, processing, distribution, purchase, sale, warehousing, or transportation of any cannabis in violation of a possession limit in the penal law known by this person to be illicit cannabis is guilty of the violation. So basically, if you're allowing things to happen on your property and you know that it should be licensed and taxed, then, and the license is implied, if you know it should be taxed, well, if you know it's illicit cannabis, then you know it should be taxed, therefore you know it should require a license.
But it's interesting, it also says violation of possession limit. What's the possession limit? 5 pounds at home of flour. I can't remember how many ounces of concentrate, and then 3 ounces, 3 ounces of flour on your person, and then
yeah,
I think like
24 grams of concentrate on your person. I don't remember what the at-home limit is.
Yeah, but it's just like, it's interesting because it's kind of a hybrid there of illicit cannabis, which is not taxed, but it's also violation of personal limit. So if you know someone has, if you own a property and you know someone has 6 pounds on them, whether it's illicit or not, because they're saying it's like, they're including that possession limit there, like that's also a violation.
But also remember, or, you know, look carefully, is guilty of a violation. A violation is less than a criminal charge. It's you know, the equivalent of like parking ticket level things where it's not criminal really. So it's interesting that they, you know, all of these things we were just talking about were misdemeanors, and then this one is, well, if you're a landlord, it's a violation. So yeah, that's just interesting. Let's see, persons forbidden to traffic cannabis, certain officials not allowed to. So individuals who have been convicted of an offense relating to, and this is, I've gotten this question a lot, you know, hey, I've gotten a DUI, or hey, I've gotten access, am I going to be allowed to get a license? So an individual has been convicted of an offense related to functions or duties of owning and operating a business within 3 years of the applicable date, except that if the board determines that the owner or licensee is otherwise suitable to be issued a license, and the board determines granting the license is not inconsistent with public safety, The board shall conduct a thorough review of the nature of the crime, conviction, circumstance, and evidence of rehabilitation of the owner in accordance with Article 23A of the Corrections Law, and shall evaluate the suitability of the owner or licensee to be issued a license based on the evidence found through review in order to determine, in determining which offenses are substantially related to the function or duties of owning and operating a business. The board shall include, but not limited to, the following: a felony conviction within the past 5 years involving fraud, money laundering, forgery, or other unlawful conduct related to owning and operating a business; a felony conviction within the past 5 years for hiring, employing, or using a minor in transporting, carrying, selling, or giving away, preparing for sale, or peddling any controlled substance to a minor, or selling, offering to sell, furnishing, offering to furnish, administering, or giving any controlled substances to a minor; a person under the age of 21; a partnership or corporation, unless each member of the partnership or corporation or each of the principal officers and directors of the corporation is a citizen of the United States, or a person lawfully admitted for permanent residence in the United States, not less than 21 years of age. So just to go back for a second, the big felony stuff is, fraud related or controlled substances involving a minor. And based on what we read before that, it's not an outright ban. They will just look at all the facts and circumstances and determine whether or not, but those are going to obviously be big red flags. So with the partnership and corporation stuff, it's either got to be United States people, citizens, or permanent residents. You can't be a foreign person and own an interest, although I'm not sure about a foreign corporation. You probably would just need to have a domestic corporation formed, but let's see. And provided further that a corporation organized under the not-for-profit law or the education law, which otherwise conforms to the requirements of the section and chapter, may be licensed if each of the principal officers and directors are not less than 21 years of age. And provided further that a corporation organized under the not-for-profit law or the education law and located on the premise of a college as defined by section 2 of the education law or otherwise conforms to the requirements of the section and chapter may be licensed if each of its principal officers and each of the directors are not less than 21. Let's see. A person who shall have a registration or license issued under this chapter revoked for cause until the expiration of 1 year from the date of such revocation. A person not registered or licensed under the provisions of this chapter who has been convicted of a misdemeanor or felony in violation of this chapter until the expiration of 1 year from the date of such conviction, or a corporation.
I'm curious, because we haven't seen felony. So obviously we've seen a lot of language around misdemeanor, but not felony. I'm curious there.
I'm pretty sure felony is when we get into the real criminal aspects and where they actually started changing the criminal law. I think that's where they have felony provisions, if I recall correctly.
Yeah. Okay.
Let's see, a corporation or partnership, if any officer, director, or partner, while not licensed under this provision, has been convicted of a misdemeanor or felony in violation of this chapter, or has had a registration or license issued under this chapter revoked for cause until the expiration of up to 1 year from the date such conviction or revocation as determined by the board. All right, so other people who can't be involved, except as otherwise provided in regulation. So big loophole there, depending on who the regulators are. It shall be unlawful for any chief of police, police officer, or subordinate of any police department in the state to be either directly or indirectly interested in the cultivation, processing, distribution, or sale of cannabis products, or to offer for sale or recommend to any registered organization or licensee any cannabis products. A person may not be denied any registration or license granted under this provision of this chapter solely on the grounds of being the spouse or domestic partner of a public servant described in this section. The solicitation or recommendation made to any registered organization or licensee to purchase any cannabis product by any police official or subordinate as here above described shall be presumptive evidence of the interest of such official or subordinate in the cultivation, processing, distribution, or sale of cannabis. Just to say one thing there, it's very interesting that in that section specifically, so again, we're dealing with this direct or indirect interest, but they specifically say being a spouse or domestic partner doesn't count. But notice they never said that in the licensing one. So if I'm a lawyer and I'm looking solely at this, I'm saying, well, then does the does the license include the spouse or domestic partner? So if I hold a cannabis license, is my cannabis cultivation license, let's say, is my spouse prohibited from holding a retail dispensary license? Because here they say it's not, but up there they didn't. And that disparity makes me kind of think maybe they include it in indirect. So it's very interesting that they specifically called that portion out. No elected village officer shall be subject to the limitations set forth in subdivision 2 of this section, the one above, unless such elected village officer shall be assigned duties directly relating to the operation or management of the police department. Access to criminal history information through the Division of Criminal Justice Services. The board can request, receive, and review criminal history information through the Division of the Criminal Justice Services with respect to a person seeking registration license to cultivate, process, distribute, or sell medical cannabis, adult use cannabis, cannabinoid hemp, or cannabinoid extract, which is interesting. So if you want to sell cannabinoid hemp or cannabinoid hemp extract, they can do a criminal background check, even though it's completely federally legal. Let's see, at the board's request, each person, member, principal officer, the applicant shall submit to the board his or her fingerprints in the form and in manner as specified by the division for the purpose of conducting a criminal history search, identifying criminal convictions and pending criminal convictions, and returning a report thereon in accordance with the procedures and requirements. So they can do criminal background checks, and they will. It's pretty much what all of that.
So did it just say at that end, it's like that they have to send a report back on your criminal background check? So it's, if you get checked, you will get a confirmation.
That's what it looks like.
A report back, yeah.
Let's see.
Let me know if you want me to scroll.
Yeah, go ahead. So I don't think there's anything in there.
Talking about the process of getting your fingerprints done, sending you to pay the costs associated with.
So wait, go back up for a second.
Fingerprints
submitted to the division pursuant to the subdivision may also be submitted to the FBI for a national criminal history search. So just FYI, you are submitting to an FBI background check. Well, you may be submitting to an FBI background check. That doesn't necessarily mean the FBI knows what you're up to. Although I guess if the request goes through the Cannabis Control Board or Office of Cannabis Management, it might be obvious.
True.
So let's see. Let's go to injunction. Basically, the OCM can request an injunction to stop the unlawful manufacture, sale, or distribution of cannabis. So basically, they would have to go to court and get an injunction for you to stop, and then now there's a court order. Severability just means that if a judge finds any part of this law illegal, unconstitutional, whatever, they can cut out that specific part without rendering the entire law illegal or unconstitutional.
That will be super interesting because we know that, like, this, as we've noted, there are a plethora of places where there seems to be inconsistencies from our end. So it sounds like that within this clause that it allows for adaptation that won't, in turn make the MRTA null. It just, we can pull out a section if it is inconsistent or if it's in contradiction with the rest of the bill.
Yep. I mean, that is pretty much in every single law. It's in pretty much every contract too you'll ever read. It's basically, protection that, hey, if this one thing is bad, it's not going to kill the entire thing. But yeah, important. Hopefully, we can get amendments before this goes to court and courts are declaring parts of it invalid and things like that. Hopefully. But yes, it's important provision. The next one is just amending parts of the public health law. I think this is where we start getting into like the criminal aspects.
Yep, for sure.
So these are all the definitions that are applicable. Do you want to go through them all, or do you want to just spot some?
I think we should cruise through them. So I mean, section 3302, that, obviously we were just, how did we get there? If you could tell me, because like we got from section 139, how do we jump to section 3302? Is that because
So if you read, go up for a sec. Section 3 is the section that we're on,
okay,
which must be section 3 to a different, because I think maybe we're in section 2. I don't remember, but you'd have to see, like, you went up and see where section 3 falls in. Now, section 3 is saying, hey, we're going to amend all this stuff. Here's specifically what we're amending.
Okay, cool. Appreciate that. So yeah, the definitions of terms of general use in this article, except where different meanings are expressly specified in subsequent provisions of this article, the following terms have the following meaning. Addict means a person who habitually uses a controlled substance for a non-legitimate or unlawful use, and who by reason of such use is dependent thereon. Administer means the direct application of a controlled substance, whether by injection, inhalation, ingestion, or any other means to the body of a patient or research subject. Agent means an authorized person who acts on behalf of or at the direction of a manufacturer, distributor, or dispenser. No person may be authorized to so act if under Title 8 of the Educational Law, such person would not be permitted to engage in such conduct. It does not include a common or contract carrier, public warehouseman, or employee of the carrier or warehouseman when acting in the usual and lawful course of the carrier's or warehouseman's business.
So Zach,
go ahead.
I think what might be helpful here is just context and what this is. So these are all the things in the public health law, the definitions, and what they're doing, what this law did is it removed certain ones.
Yeah.
So
like we can see, cannabis, concentrated cannabis has been erased under this section.
Right. And, the next one, controlled substances, they remove, well, actually, I think they amended, and I think it's in here. Actually, I'm pretty sure it is. The controlled substances, they remove cannabis from a controlled substance. So that's really what all of this is doing, is all of these definitions are already in the law. They're just saying, well, we're pulling out cannabis concentrate and, if they pull out any others. So yeah, that's just a little context.
No, that's great.
Yeah, I don't know if we want to read through every single one of these, because again, these are not changing. These are already in the law. Yeah,
no, I think that's good. I do want to say, like, delivery, there's a few things that have been highlighted. Delivery means an actual or constructive or attempt to transfer from one person to another of a controlled substance, whether or not there is an agency relationship. The dispense means to deliver a controlled substance to an ultimate user or research subject by lawful means, including by means of internet and including the packaging, labeling, compounding necessary to prepare the substance for such delivery. Distribute means to deliver a controlled substance, including by means of the internet, other than administering or dispensing. Yeah, so it's like things that like seem pretty darn commonplace, but it's like when it comes back, like why do we need these here, Jason? Like what's the point of having these listed here?
Well, so I think because there was a lot of cross-referencing, like, this is all saying these are, if you're dealing in controlled substances, this is, a lot of this is because you see this controlled substances coming up again and again and again. This is all dealing with, under the public health law, what happens, or the definitions of people and transactions within the context of controlled substances. So realistically, for cannabis purposes, this all becomes moot, because I am pretty certain that cannabis is no longer a controlled substance in New York, and therefore none of that's applicable. It's all under the MRTA provisions, not the public health law or anything like that.
It's interesting, in manufacturers, as means the production, preparation, propagation, compounding, cultivation, conversion, or processing of a controlled substance, either directly or indirectly, or by extraction from substances of natural origin, or independently by means of chemical synthesis, etc. It's interesting to see like cultivation in there, which of course it's part of the manufacturing process, but when we're looking at licensing, like, does that have an impact on definitions, etc.? Like, because we talk about, like, do you need a manufacturing license to be a trimmer? Like if you want to trim or process, and like obviously here manufacturer has a specific definition. Does that inform the license, or is this just a standalone thing?
I mean, I would say that this has no bearing on that because this is the public health law. So unless they make a specific reference to the public health law, I don't think so.
Mhm.
This is really dealing with, because remember, controlled substances aren't just the Schedule 1 highly illegal, no medical usage, blah, blah, blah substances. They're anything that can require a prescription potentially. So this
True.
is really a
True.
lot governing too, like how drug manufacturers work and things like that. It's really saying if you're handling a controlled substance, this is all applicable. But unless the MRTA makes specific reference to the public health law, then I would say that it's relatively not, it's moot. For the most
Right.
part.
Like you can see, they removed marijuana by definition, of course, because that's been included elsewhere. So we'll keep on. Oh, poppy straw. I think that's just kind of interesting to see as we're scrolling through here. By means of the internet, electronic prescription. So it's all stuff folks can look at. Obviously, we're on page 80 of the MRTA. If folks want to look at, see what the actual, like the medical definitions are, et cetera. Mescaline, yeah, the list keeps on going.
But hold on one second.
The deltas, yeah.
Yeah,
go ahead.
go. So notice tetrahydrocannabinol. So synthetic THC is not derived from the cannabis plant that are equivalent to substances in the plant. Those are still a controlled substance, or my guess is probably will be. That's what they're defining what THC is and saying synthetic THC.
Well, you know what's fascinating too, because like there's a bunch of like there's a big discussion in the scientific community about making lab cannabinoids, you know, growing it off different bacteria or fungus, you know, and like technically that's synthetic and wouldn't be allowed, even though it could be, you know, your picture perfect THC molecule. If it was grown in a petri dish, it doesn't count.
Yeah, I mean, basically anything not naturally occurring is synthetic, and that's what they're kind of going after. And my guess is some of these definitions for that are going to get more and more expansive as you get to like other things that aren't necessarily described, that like the variations of THC, THCP, V, you know, all of this stuff. Those aren't described by that, but they're clearly going to want to regulate that. If they allow it at all, they're clearly going to want to regulate it under the adult use law.
Dave says a term I've also heard is bioidentical. Yeah, that's interesting, Dave. It's interesting here too, like we don't need to dive into, but like beginning to talk about retail tobacco businesses and like cigar bars, membership associations, outdoor dining areas, like beginning to outline where smoking is and isn't legal. And I think that's important to acknowledge, at least because like, you know, as the law reads, anywhere you can smoke tobacco, you can smoke marijuana. So
this is that because there is that general prohibition on smoking indoors in New York, but the law contains those exceptions, which say cigar bars and things like that are allowed. So that's what, you know, that's why this is all relevant.
Yeah, it's interesting. Like outdoor dining areas of food service establishments with no roof or ceiling enclosure provided. However, smoking and vaping may be permitted in a contiguous area designated for smoking and vaping, so long as such area constitutes as no more than 25% of the outdoor seating capacity. And such food service establishment is be at least 3 feet away from an outdoor area such as a food service establishment not designated for smoking and vaping. So basically, like you can't be smoking 3 feet away from where smoking's not allowed.
As we know, smoke only travels 3 feet.
Then talk about enclosing stuff. So it's all interesting. You know, enclosed rooms and food service establishments, bars, catering halls, conventions halls, hotel, motel, conference rooms, and other such familiar facilities during the time such enclosed areas or rooms are being used exclusively for functions where the public is invited for the primary purpose of promoting or sampling tobacco products or electronic cigarettes, and the food, service, or drink is identical to such purpose, provided that a sponsor or organization gives notice, and all promotional material or advertisements that smoking and vaping will not be restricted, and permanently post notice at the entrance of the facility, et cetera. So again, just kind of looking at the details where if you're going to have a smoking convention, what folks will have to do to prepare for that. Adult use. So they added here, you know, retail electronic cigarette stores, provided, however, that such stores may only permit the use of electronic cigarettes, and adult use on-site consumption premises. So this is where they added in. The green is the adding in because they now have to include adult use on-site consumption premises authorized pursuant to Article 4 of the Cannabis Law, provided, however, that such locations may only permit the smoking and vaping of cannabis. It's interesting. And then Article 33B is repealed. We want to look here at Section 6B.
Basically, I think that's the medical, and they're just saying, okay, health department, you're transferring medical all the way over, and cannabinoid hemp to OCM.
And as we continue here, let me know if anything stands out to you, Jason.
Yeah, I mean, I think there's a lot of just administrative stuff.
Yep. Paragraphs. It's interesting because the conviction of a person in a criminal action upon accusatory instrument, which includes felonies specified for subdivision 4B. So obviously it begins to kind of look at the realm of felonies, but it goes back to specific, points within this bill. Any stipulation, settlement, agreement. Again, if anything's, go ahead.
Here's where they're starting to amend and put cannabis in. Section 222.00 of the penal law. So that's where all of the criminal conduct for cannabis will be.
And then, so here we're looking at section 114A of the vehicle traffic law, also adding cannabis concentrate, et cetera.
So that would be like applicable to DWAI drugs, because there's DWAI, which is driving while ability, or DWAI is driving while ability impaired. That's alcohol. Then there's DWAI drugs. Now cannabis is brought under that to make sure that, yep, this is also something that it is included.
And then we look at 9A. This is like labor law. So like, an individual's legal use of consumable products, including cannabis, in accordance with state law prior to the beginning or after the conclusion of an employee's work hours and off the employer's premises and without use of the employer's equipment or on their other property. Individuals' legal recreational activities, including cannabis, in accordance with state law outside of work hours, off the employee's premises and without use of employer's equipment or property. So this is just putting it in law that those things are okay under New York state law, that you can't, someone can't be fired for such activities.
Subject to the next big chunk of green.
Yeah. Notwithstanding the provisions of subdivision 3 or 4 of this section, an employer shall not be in violation of this section, whereas the employer takes action related to the use of cannabis based on the following. 1, the employer's actions were required by state or federal statute or mandate. The employee is impaired by the use of cannabis, meaning the employee manifests specific articulable symptoms while working that decrease or lessen the employee's performance of duties or tasks of the employee's job or position, or such specific articulable symptoms interfere with employer's obligation to provide a safe and healthy workplace free from recognizing hazards as required by the state. And 3, the employer's actions would require such employer to commit any act that would cause the employer to be in violation of federal law and would result in the loss of federal contract or federal funding. So that's
those
a big
are all
thing.
important big things. And I will also give you one massive loophole. Let's say that your employer just finds out, you didn't even tell them, they just find out that you smoke cannabis and they have some kind of aversion to that, don't like it. There's nothing in the law, because we're an at-will state, that says they can't just fire you and not give you a reason. Now, if you can figure out that the reason was for cannabis, like if they were dumb enough to put it in writing, you could go after them. But just understand that if they don't articulate that reason, we're firing you because of cannabis, or you can't prove that they are, that doesn't mean they can't just fire you. Now that changes a little bit if you're under the medical law because you're disabled under the New York State Human Rights Law, so you get a few more protections. But just be aware this could become, you know, an issue where the employer just doesn't tell you why. You may suspect it, but unless you can prove it, we're an at-will state. So that's a problem. You do have protections, and these are probably some of the best protections in the nation for adult use, but at-will employment can kind of negate some of that too.
Appreciate that. Penal law. So yeah, I mean, that honestly just takes us through to the end of our general provisions, Article 6. And obviously that we get back into the next up is Article 222, cannabis, and it defines cannabis at home cultivation, et cetera. This will definitely be interesting stuff. What do you think, Jason?
This is actually still, I think, part of the general provisions. They're just putting in this whole new Article 222 into the penal law.
Okay, sweet. Well, that means, guess maybe we should take a pause. Does anyone have any questions out in the audience, whether it's referring to what we covered or something we may have covered some time ago? Feel free to drop it in the chat or the Q&A. Because as you can see, like, we've covered a lot of bases and there's a lot of layers, like the way the law like meshes in with these different articles, and then you see it summarized in a sentence somewhere downstream. It can definitely be pretty confusing. All right, well, cool. I mean, Jason, what do you guys think? Jason, Mary, should we pause here and then dive into Article 222 next session? We got like 8 minutes. Your thoughts?
That's fine with me.
Cool.
I think it's a good, clean place to stop.
Yeah, as do I. Well, cool. Thanks everyone who's been on this call. Hopefully we got some more insight. As you can see, we're going next session. We'll be looking at Article 222, which, you know, we're looking at the definition of cannabis, personal use of cannabis, restrictions on cannabis use, personal cultivation and home possession of cannabis. So this is going to lay out, you know, how much you can have on your person or at home, et cetera. The licensing of cannabis production and distribution, defense, unlawful possession of cannabis, criminal possession of cannabis in multiple degrees, unlawful sale, and the criminal sale all the way through. So this is definitely where we're beginning to see amendments to at home and personal use, as well as revisions to what the criminal code looks like. So it'll be pretty darn interesting for folks in the industry as well as consumers in general. Yeah, Jason, Mary, thank you both for making the time to be here today. It's definitely a lively conversation in a place where it can be a little dry. So appreciate your perspectives as always.
Thank you for having me.
You as well. Thanks, Zach.
Yeah, of course. Let's see, we got something in the chat. Thank you, Jessica. Yeah, thanks everyone who's on the call. It means so much. Dave, Jessica, Laura, Matthew, Melissa, and Brown, Ram, thank you guys so much. Reach out if you have any questions. We're here. And no matter what, we will see you next week, and take care.
See ya.
Bye now.